everybody. This is your student aide here, and today I will be talking about civil rights, civil liberties, some liberties and rights guaranteed in the United States Constitution. There's Schneck versus United States, the Fourth Amendment rights, and much more. So let me get started. Civil rights is the basic right to be free from unequal treatment, which is based on certain characteristics which we deem important, like race, gender, and disabilities. This is protected by the Fifth Amendment, 14th Amendment, and congressional legislation. Now, the Fifth Amendment is against the national government. It protects the people from national, state, or any unequal treatment. It's also protected by the 14th Amendment, which is against the state government, especially the equal protection laws, which I will be getting into. It'll also be protected by congressional legislation, which is anti-discrimination or equal treatment. So, civil liberties is the basic freedoms guaranteed by the Bill of Rights or interpreted through the years by courts and lawmakers. The constitutionally protected freedoms of all persons against governmental restraint. So civil liberties, the main topic is it's against governmental restraint to protect the people, and this is just a basic right to be free from unequal treatment. These civil liberties are also protected by the due process and equal protection clauses of the 5th and 14th Amendment. This is very important. If you are studying for a dual enrollment or AP government exam, this is definitely going to be on there. It's protected by the due process, which is the clause in the 14th Amendment says that the states cannot deny life, liberty, or property without due process of law. I will get into the equal protection clauses later. So some essential civil liberties which are guaranteed in the United States are the right to privacy, right to jury trial, right to freedom of religion, right to freedom of speech, right to bear arms, right to legal counsel, right to vote. So these are guaranteed in the United States Constitution. But remember that the liberties or rights can sometimes be in the original text of the Bill of Rights or be created by court case decisions. One right to free speech court case was Schneck versus United States. This was very important. This was the one when Schneck violated the Federal Espionage Act. This law prohibited all false statements intending to interfere with the military forces of the country or to promote the success of its enemies. So Charles Schneck, he violated these laws and he was arrested and then convicted for sending 15,000 anti-draft circulars, which are pamphlets, through the mail to men scheduled to enter the military service. So the government did accuse Schneck of illegally interfering with the military recruitment under the Espionage Act. He was admitted that he sent the circulars, but argued that he had a right to do so under the First Amendment, and was merely exercising his freedom of speech. But the government convicted Schneck because he was illegally interfering with the military recruitment under the Espionage Act, and that overruled against the First Amendment right. So the Fourth Amendment rights in court case, freedom from unreasonable search and seizure, which is guaranteed by the Fourth Amendment. A tip for all of you students is that you may want to memorize all of the first 10, first 15 amendments of the Constitution, the Bill of Rights, because this is very important. Your teacher may test you on those, so that's very important. So the Fourth Amendment, again, is the unreasonable search and seizure. To prevent the abuse by police, which is the Constitution requires the searches of private property are permissible only if probable cause exists that indicates that a crime may have taken place. For example, one of those cases was the Mapp versus Ohio. This is a 1961 case in which the police broke into the home of Dolly Mapp, a woman under suspicion for illegal gambling activities. They instead found obscene materials and arrested Mapp for possessing them. She did appeal her case, claiming that the Fourth Amendment should be applied to state and local governments and that the evidence had been seized illegally. The police, she claimed, had no probable cause for suspecting her for the crime she was arrested for, and the court ruled in her favor, thus redefining the rights of the accused. So that is very important because the government actually did coincide with Mapp, and they agreed with her because this is mainly to prevent police misconduct, and Supreme Court ruled that the evidence obtained unconstitutionally cannot be used in courts against the person whom it was seized. So now we're moving on to the exclusionary rule. The exclusionary rule prevents the government from using evidence in trial which was derived from an illegal search, seizure, arrest, or interrogation. It's kind of the same thing. This was established by the Mapp versus Ohio, and there are exceptions to this exclusionary rule. There would be inevitable discovery and in good faith. There is the inevitable discovery, which is the law that states evidence that was found using illegal means could still be admissible in court if the evidence would have been found eventually anyway using illegal means. If you don't quite understand the definition, it is kind of hard. I do understand that. You can go online. There should be a better story example of how inevitable discovery would be applied. It just basically means that the officers would have found the evidence legally eventually. And then there's also the in good faith, that the warrant was valid. For examples, if the judges or legislators make errors to the warrant, then the judge, for example, makes a mistake, and then the police officer is not responsible if she or he had good reason to believe that the warrant was valid. These two are exceptions to the exclusionary rule, and this is very important. So, some rights in the original Constitution, and then is the right of habeas corpus, no ex post facto laws, and no bill of attainder. So these three are very important. They are rights in the original Constitution. They are not established by any court cases. The original framers wrote this in the Constitution. Now, habeas corpus means produce the body. It's very simple. Just remember that it just produced the body, meaning that it requires the governmental officials to present a prisoner in court and to explain to the judge why the person is being held. So they just can't, they cannot arrest someone and put them in jail just because they want to. It requires the government officials to present the prisoner in court, and then the prisoner can express his argument to why. No ex post facto laws, meaning Latin for after the fact, and it punishes a person for something that was not a crime when he did it. It may not be passed by Congress, meaning that if, for example, abusing dogs is now illegal, but people in the past have done that, they cannot be convicted because it is after the fact. It's already established. So no bills of attainder is an act of legislature. It is prohibited for federal and state government to do, declaring a person or group of persons guilty of some crime and punishing them without a trial. So bills of attainder is kind of like you need to have it with trial. You cannot just tell someone you're guilty and then punish them without trial. You can't do that. You have to have them with trial, in front of a jury or a judge. So Fifth Amendment rights, which is no self-incrimination. You have the right to remain silent. It's a very simple one. You do not have to testify against yourself, which is, I plead the fifth. This is designed so that the burden is on the government to prove guilt. So the Miranda warning, this is where you have the right to remain silent thing is. Miranda rights, that's where it's come from. So Miranda versus Arizona, the Supreme Court announced that no conviction could stand if evidence introduced at the trial had been obtained by police during custodial interrogation, unless suspects have been notified that they are free to remain silent, warned that they may use against them in court, and told that they have a right to have attorneys present during questioning, and blah blah blah. Those are the Miranda rights. That have been established by the Miranda versus Arizona. So another one underneath the Fourth Amendment rights is double jeopardy and grand jury indictment. Double jeopardy is you cannot be held in court and be tried again, even if you're found innocent or guilty. You just cannot be tried again. Grand jury indictment is necessary in order to require anyone to stand trial for a serious crime. Grand jurors are concerned with whether there is enough evidence to justify a trial, and the protection against the government putting someone on trial for no good reason. So these three, or these four, are under the Fourth Amendment, and you definitely need to know that. So the Sixth Amendment rights are basically the right to counsel, and it's more of speedy trial, public trial, right to obtain witnesses, fair cross-section of the community right here. So the right to counsel. So every person has the right to a lawyer. Well, I can't speak. In Gideon versus Wainwright, the United States Supreme Court ruled that the Sixth Amendment right to counsel provision applies to those accused of major crimes under state laws. So think of this as if a person went out and just stole bubblegum. I mean, like, and they're poor and they cannot afford an attorney. It only applies to those of major crimes under the state laws and those who are accused of major crimes. It's more of, fatality, and just major crimes in general, not stealing a pack of gum. That's the state is paying for your lawyer, and so they want to do it on major. They don't want to waste the money for a gum snatcher. So other Sixth Amendment rights is government is obligated to give defendant a speedy trial. The government is obligated to give the defendant a public trial. An impartial jury consists of persons who will represent a fair cross-section of the community, and the defendant has a constitutional right to obtain witnesses in his or her favor. So these are under the other Sixth Amendment rights. So that's the Sixth Amendment. The Eighth Amendment is just no excessive bail, no cruel and unusual punishment shall be used against a convicted criminal. You can't be sent to death row just because you stole a pack of gum. That's stupid. That is cruel and unusual punishment. So selective incorporation is the ability of the federal government to limit state laws making power. And the Incorporation Doctrine is a constitutional doctrine where specific provisions of the Bill of Rights are made applicable to the states through the Due Process Clause of the 14th Amendment. These two definitions you definitely need to know for your AP exam for government or any midterm exams underneath the civil liberties. So the case Gitlow versus New York, it said that states may not deny free speech and press. These were protected by the 14th Amendment Due Process Clause. Yes, so non-protected speech. Let me move on to speech. So there is non-protected speech, which is libel and slander, obscenity and pornography, fighting words, and commercial speech. You definitely need to know non-protected speech and what is underneath that, and protected speech and what is underneath that. So libel and slander, which means libel is a written defamation, and slander is just spoken. Just think about that. Slander, spoken, libel, written. Libel is a written defamation that falsely attacks a person's good name and reputation. The reputation is very important. Slander is a spoken defamation that falsely attacks a person's good name and reputation. For example, Hillary Clinton screaming that we're a basket of deplorables. I mean, it could hurt someone's reputation. I am an unknown person, so it really wouldn't matter to me. But for example, also Trump speaking that Hillary Clinton is something this and this. He's falsely attacking someone. Same thing with anybody else. This is a non-partisan channel, so don't attack me. There's underneath is obscenity and pornography now. It really just states that it must lack serious literary, artistic, political, scientific value. For example, if you have a picture of a nude man, okay, people do, no judging, it's a piece of art, and some people might say that this is pornography, it's obscenity, but they have to prove that it must have literary, artistic, political, or scientific value. That's pretty much it. So fighting words it's the very utterance of inflict injury or tend to incite and violence or breach of peace. For example, if the KKK come in and they come into a very populated Black community, and they are trying to incite violence or breach of peace, that is fighting words. If they speak that, this is not press. This is not, you're not writing this. This is actually spoken. Same thing with slander. This is kind of like, but this is way worse. You're intending to incite violence. So commercial speech is such as advertising. It was an example of the Citizens United versus United States, because, for example, they posted that Hillary's something movie, and it was all about how she's bad and she's corrupted. It's kind of like a commercial speech. They did win the fight, though. They were allowed. And this is kind of out of the blue, but it did. The Citizens United versus United States, they did establish the super PAC. That's how super PACs were established, but that's kind of not what we're talking about. But just an example, a commercial speech. It's such as if advertising is more restricted than our expressions of opinions on religious, political, or other matters. And the FTC decides what kind of goods may be advertised on radio, television, and regulates the content of such advertising. Now, moving on to protected speech is prior restraint, which is basically just the government preventing material from being published before it even is published. And then certain forms of symbolic speech and pure speech. Those are two different things. You definitely need to know what's the difference between symbolic speech and what is the difference between pure speech. I did not write it on here, but hopefully you can go on and you will learn more about symbolic and pure speech. Symbolic speech, such as wearing black armband at school, at protest of Vietnam War, and flag burning. Yes, flag burning, in my opinion, I completely disagree, should be banned, but it is a form of symbolic speech. And yeah, I mean, it is protected, so that, fortunately, but yeah. So the Establishment Clause is the First Amendment, prohibits the government from establishing an official search. And this is all about the freedom of religion I'm going to get into. The Establishment Clause, they don't want the government to promote or advocate for one specific religion, because that is kind of discriminatory. Do you get what I mean? You're establishing an official church, which is not allowed. We want a wall of separation, which is one of those key terms you need to know. A wall of separation between the state and between the government and the church. So example is Lemon versus Kurtzman, which has established a 3-part test to determine if a statute or practice violates the Establishment Clause. So these 3, I guarantee you, will be on your test. Definitely, because this is parts of the 3-part test. What you need to know is if your government starts to establish or violate your religion or someone's religion, you have to look at this first. First step is primary purpose is religious. Is the purpose of the government religious or not? Second is the primary effects advances or inhibits the religion. And 3, a lot of entanglement with government or not. If any of these are present, the statute or practice is unconstitutional. Now, getting into the free exercise clause is it does not allow any laws prohibiting the free exercise of religion. The Supreme Court has never allowed religious freedom to be an excuse for any type of behavior. It has consistently ruled that people have an absolute right to believe what they want, but not necessarily a right to religious fact that may harm society. For example, I thought I had a picture, but for example, I think the Amish people, no offense to the Amish people out here, if you're my viewers, but the Amish people, I believe that in their religion, I read this online, in their religion, they are not allowed to pay taxes, but this does harm society because the government needs the taxes to pay for the roads and everything. So this is against the free exercise clause. That's how they established this. So yeah, that is civil liberties, civil rights, kind of this everything together. And I hope you understood what I was saying. I do realize sometimes you guys go through some videos, you have no idea what they're saying. I did speak a little fast, so if you want, you can slow down my speaking. I did slur a couple times. I'm so sorry about that. I hope you understood it. You can pause the video if you want to go through. I'm going to just slowly go through a couple of my pages for anybody who wants to stop, because I know I was a little bit fast. And that's me also in some of my videos. So yes, this is your student aid. I hope you enjoyed this video. I will get more into my AP governmental curriculum, and hopefully you guys will subscribe, because that really, really helps. But yeah, thank you for watching, and hope this made sense. All right.